It is no exaggeration to say that class actions, the advent of class actions, introduction of class actions in Canada has radically altered the litigation landscape. And depending on who you ask, that is either a cause for celebration or despair. And my suggestion to you today is that the truth lies somewhere in the middle, that there is tremendous potential in class actions, but that our recent experience demonstrates that there are also pitfalls. Yesterday we heard from the president of the Chilean Supreme Court, Hugo Domnech, and he asked, how do we build a more equitable system of justice? How do we reduce barriers to accessing justice? I would suggest to you that class actions play a role in that discussion, and so what I'm hoping you will do is take from the Canadian experience what has worked and learn from the Canadian experience what hasn't as you begin to explore this vehicle in Latin America. What I'm going to do to begin is review the history of class actions in Canada, talk about the theory of class actions, and then briefly illustrate the structure, the regime that we have adopted. Then what I propose to do is to lead practical exercises to build hard skills in class action practice and to demonstrate how class actions are done in Canada, not to say this is the only way to do class actions, not to say it's the best way to do class actions. It happens to be the way that I know. And so the idea will be to take away some common themes from the Canadian experience that I hope will be more generally applicable. So beginning with the history of class actions in Canada, although the province of Quebec, and I should say class action legislation is done at the provincial level, it's not done at the federal level, province by province. The province of Quebec, which is a civil law jurisdiction, introduced class action legislation in 1978, somewhat different than what we would recognize today as class action legislation. That begins with a discussion that came out of my province's Law Reform Commission, the Ontario Law Reform Commission in 1982. That report sought to build on the American example. As Professor Verbeek says, the Americans have been at this for many decades longer. They have a very well-developed jurisprudence under their Federal Rule 23. And the idea in Canada was to look to their example, take from it what we thought was good, and improve upon it. And that's what the Ontario Law Reform Commission's 1982 report sought to do. Beautifully written report, lengthy, detailed, thoughtful, and it sat on a shelf and it gathered dust for another 8 years because there wasn't the political will to implement it. That is the other component to this, of course. All the good ideas in the world do not much good if you don't have the political will to implement them with legislation. The right government came along. By the end of the 1980s, we were in the process of trying to implement this idea of class actions. By 1992, we had a statute, the Class Proceedings Act in Ontario, followed in 1996 in British Columbia, and then, remarkably, in 2001, the Supreme Court of Canada held that regardless of whether a statute existed in a particular province, there was a common law, an inherent right to a class action procedure that applied to all Canadians. And it was on this basis, then, that the other provinces followed, introduced their own class action legislation, such that today, across Canada, with the exception of one province, there are class proceeding statutes in every province and territory. That's the history of class actions. I think the more interesting question is why class actions? What end do they serve? What's the purpose? And Professor Verbeek did a very good job of explaining the rationale for class actions in terms of pooling the costs of litigation for plaintiffs. What I would do is simply put that in dollar terms. Take, for example, purchase of a consumer good, let's say a microwave oven. If I buy a microwave oven, it doesn't work, I feel it's defective, I feel it's actually a defect in the manufacturing, and I want to seek redress. Let's say the microwave oven costs me $100. And let's say that if I intend to seek redress in the courts, the cost of litigation is going to be $50 in attorney's fees. Now, rationally speaking, a defendant and a plaintiff, if they are assessing the litigation from the same perspective, will be prepared to settle that case at the value, the expected value of the claim adjusted for litigation risk. Let's say it's $100. I have a great case. I'm going to win if I can just get to judgment. The problem is that with the costs of litigation, what I really need to recover in order to get my $100 is $150. I need to pay my attorney. I need to get my $100. That replaces my microwave oven. And in that situation, I'm very unlikely to reach a settlement. The defendant thinks my claim is worth $100. I know my claim is worth $100, but because of the cost of litigation, I need $150. What a class action does is it reduces the importance of the cost of litigation. When we add that second plaintiff with the same microwave oven, with the same defect, the cost of litigation is not each of us paying a lawyer $50, it is perhaps, instead of $50, $60. And so for each of us, the amount we then have to recover is $130. We're each paying $30 for the lawyer. And so you can see that as you add more plaintiffs with the same cause of action, the economic result in terms of dollars and cents is to bring down the expected recovery and the necessary recovery in order to settle the action. And so as the costs of litigation decrease, the plaintiff and the defendant get closer together and in theory get closer to settlement. And at the same time, the defendant, as the number of plaintiffs increases, is feeling greater pressure to reach a settlement because the costs of losing are that much more disastrous. When you have thousands or millions of plaintiffs, the stakes are higher. And so the idea is, in theory, that this process of aggregation of litigation drives settlement and optimizes economic outcomes from litigation. However, it does so at a cost. It does so at a cost to the justice system in terms of public resources that are consumed in this process. It's a very resource-intensive process to manage a class action, let alone to try a class action on the merits. And it imposes significant costs on defendants, and in that sense on the economy as a whole, in terms of the cost of doing business. And so there needs to be a normative justification for class actions. There needs to be a rationale, a raison d'etre for class actions. And it's that normative justification that comes for Canadians from the 1982 Ontario Law Reform Commission report. Francisco explained 4 normative justifications. For us in Canada, it was only 3. They are judicial economy, access to justice, and behavior modification. And those are the 3 justificatory rationales that, for us, explain why it's worthwhile to have class actions. When you look closely, though, at the track record of class actions, I would suggest to you that, in fact, from 3 rationales, there are actually only 2 that play in practice, and really only 1.5. Judicial economy works insofar as the cases that are brought would otherwise have been litigated in an individual capacity. We go back to my microwave oven, $100. Let's be honest, $50 is not actually the cost of legal representation. I would never actually pursue that case on my own in court. It would be, as Professor Verbeek says, one of those cases where the defendant enjoys impunity. It would not have been commenced but for the fact that I had access to a class action. So judicial economy was initially conceived as an important rationale for class actions. And in some cases it will be. In Canada, we allow much greater scope for class actions to recover on mass torts than they do in the United States of America. And so where there are personal injury cases, and we'll talk about how class actions can help to advance, if not entirely resolve, personal injury class actions. In those cases, yes, it is much more efficient to have a single judge, at the very least hear the common issues phase of that kind of a case, as compared to having multiple judicial processes and multiple different courts, of course, with the risk of conflicting results. But judicial economy, by and large, in our experience in Canada, has not been a significant rationale for class actions. And this is particularly true in the consumer sphere, which seems to be the most readily accepted area for class action practice in Latin America. So it's not judicial economy, but that's all right, because as the Law Reform Commission recognized in its 1982 report, even where there's no judicial economy, the fact that a case would not be commenced individually does not mean it's unimportant. It does not signify that this is a case that should be ignored, that it's all right to pass it over. As Professor Verbeek said, there are barriers to accessing justice, as you all well know. One of those barriers is the cost of litigation. That's one we've covered. But another is the social stigma to accessing the courts. This is particularly true of vulnerable members of our society who are unfamiliar with the court process, or perhaps who are all too familiar with the court process, for example, from criminal proceedings, and reluctant to bring a civil case lest they engage with this system they distrust. And so for these individuals, it may not be a case that the $100 claim is not worthwhile recovering. It may instead be a case that they have a significant claim that they do not want to or do not know how to recover in the courts. And so access to justice is about helping these people who would not otherwise be able to advance their action, or who would otherwise be able to advance their action in the courts, but at greater cost. In other words, making the process more efficient. It begs the question, of course, that we've assumed that plaintiffs want to access the courts, that they want to seek legal redress for a violation of their rights. That is one of the baked-in assumptions of class actions, and of course it's subject to challenge. My microwave oven may have broken, I may not care. And so one of the critiques of class actions is that the assumption is always that I do care and I do want redress, and I do want to put the public system to the cost of adjudicating my claim and the defendant to the cost of defending it. And the real difficulty comes in class actions, as we'll see, where ultimately there is no money returned to class members. There is only the third rationale, behavior modification, and, of course, a large fee for the attorneys representing the plaintiffs. So we'll come back to this tension, because access to justice is presumed to be a motivating factor wherever there's been a wrong. We'll question whether that is in fact true. However, the Law Reform Commission is very big on backup, you can see. So if you don't have judicial economy, if you don't have access to justice, nevertheless, even if the plaintiff does not care about the claim that's being advanced, I don't care about my microwave oven, behavior modification comes into play. And behavior modification says that there is a social good to ensuring that the defendant here, the manufacturer of my microwave oven, does not enjoy impunity. That there's a social good to ensuring that this defendant internalizes the cost of the delict that it has visited on the public. And so behavior modification is the third justificatory rationale that says, at the end of the day, even if the plaintiffs don't get any money, even if they would never have brought their case in the first place, we should have a class action because it will help to correct the behavior of the defendant. Interestingly, the Ontario Law Reform Commission in its 1982 report very clearly stated that behavior modification was not a sufficient justification for a class action. It was a benefit, but it was not itself sufficient to justify the public resources and the burden on the defendant. And as we'll see when we look at some of the cases, over time that perspective has shifted, and we now seem to readily embrace instances where behavior modification, where lawyers acting as private attorneys general, entrepreneurial lawyers, are effectively performing a regulatory function that would usually have been performed by an organ of the state. So that is the basis, the normative justification for class actions in Canada. The question then is, what do our class actions look like? This is a very complicated diagram. This is why class action lawyers in Canada get paid lots of money to figure this stuff out. But I'm going to walk through it, and we're going to come back to this in the practical training exercises. You'll see that I've highlighted in red the three very key areas of class actions that we're going to be covering in the practical exercises: certification, the common issues trial, and the approval of a settlement. Beginning on the left-hand side, a class action begins, like any other civil case, with a statement of claim that outlines the alleged facts that are sufficient to justify the damages claimed by the plaintiff. And that statement of claim is usually commenced by a very small number of plaintiffs. It can be as few as one plaintiff. It can be two plaintiffs. It looks like an ordinary statement of claim, but it alleges a wrong, or it at least raises an issue that is shared with a broader group of members of a proposed class. So you start with your statement of claim. At this point, the only people who are represented in this proceeding are the people whose names, the individuals whose names appear on that statement of claim. There is no class action. There is only a proposed class action. What needs to happen is that the plaintiff brings a motion to certify a class action. There is a judicial gatekeeping function here. And the reason for that is that the court is concerned that not just anyone starts not just any class action. You are about to engage, as I said, enormous public resources. You are about to put the defendant to significant cost. And the only way that we can justify permitting a single plaintiff to do that is if the court considers that this class action is in an appropriate form such that it can be resolved in a fair and equitable manner. And that's the question that is asked on certification. On the motion for certification, the court is not testing the merits of the claim. The Ontario Law Reform Commission's 1982 report actually did recommend a preliminary merits test. That was rejected when we came to implement the legislation because we felt that it imposed too high a barrier on plaintiffs at too early a stage. In other words, it created an obstacle to accessing justice by forcing plaintiffs to invest at an early stage in demonstrating the merits of their claim. So certification is an entirely merits-blind process. It is only about the form of the action. And so very little evidence is required. Certification is either granted or rejected. If it's rejected, you have the right to seek an appeal. But if it's rejected and you do not reverse that decision on appeal, that is the end of your class action. Not the end of the world. Remember, the only person who was in this class action at this point was the plaintiff and that statement of claim. Another plaintiff can try again. Practically speaking, it's unlikely the same reasons for which the certification was rejected will likely apply in a second case. But just because you have a bad plaintiff who comes forward at the start doesn't mean that everybody else in that proposed class is out of luck where the motion for certification fails. If your action is certified, though, you now have a class action. And the plaintiffs have tremendous leverage in negotiating with the defendant. Thousands, potentially millions of cases, hundreds of millions, billions of dollars at stake. The kind of risk that might wipe out many defendants should they lose. And this tremendous leverage, both a blessing for the plaintiff, a curse for the defendant, is part of the critical analysis of class actions. Is it fair to make a defendant face this kind of leverage at such an early stage in the action without the merits of the claim ever having been tested? And that's a discussion that we'll come back to in our practical exercises. The importance of getting certification right and the consequences of granting certification. As I said, tremendous leverage, and so one of the things that often happens once certification is reached is you get a settlement. Now, this settlement is no longer just on behalf of the plaintiff who filed the statement of claim. At this point, the settlement is on behalf of the entire class. When that class was certified, a definition of the class was accepted. That definition identifies all those who will be bound by the decision. The definition is objective. You don't necessarily know all of the people in your class, but using that definition, you can identify all of the people who are bound by the result. And so the settlement, negotiated by the lawyers acting for the person who commenced the class action, now the representative plaintiff, negotiates a settlement. The representative plaintiff accepts the settlement, directs his or her lawyers to accept the settlement on behalf of the class. The settlement is then provisionally concluded, but it cannot bind anyone other than that representative plaintiff unless it is approved by the court. Why do we care about approval by the court? Because up until this time, the only people who have had their hands on the case, so to speak, is that representative plaintiff and the representative plaintiff's lawyers. And a whole larger group is going to be bound by this result. They may never have heard of the class action. They may not be interested in the class action, but their rights are going to be determined by the class action. And they're going to be determined whether or not they know about the class action, whether or not they object to the class action. This decision will bind them. This is where you can start to see some of the advantages of a class action for defendants. It's peace. They buy peace from one set of lawyers in one court once and for all time. And so the court, in approving a class action settlement, has a very significant duty to test the fairness of that settlement in order to protect the interests of the absent class members, again, who may have no knowledge of the proceedings and no opportunity to make themselves heard. And so settlement approval is necessary before that settlement can bind. If the settlement is approved, you come to the matter of fees for plaintiff's counsel. Plaintiff's lawyers work to incentives, as Professor Verbeek said. The incentives generally in our system are a contingency fee. You get paid if you win, and you get paid something in the order of 25 to 33% of the amount of money that you win for the class. This can end up being a huge sum of money in a large class, and it is often commensurate with significant risk that has been assumed by plaintiff's counsel. When those lawyers were retained, they were retained back at the start by one plaintiff, and so it would be unfair to visit that retainer agreement, that agreement as to fees, on the entire class, which had no say in hiring a lawyer. Didn't even pick the lawyer. And that's why the court gets involved, to make sure that the fee that is being paid to the plaintiff's lawyers is fair. And fairness is a consideration not only of the work that went into getting a result for the class, not only of the risk that was undertaken by plaintiff's counsel, but also of the substantive result that was achieved for the class. And we'll talk when we come to some of the cases and the practical exercises about how a court looks at the fee to which plaintiff's counsel is entitled. Now, if you don't get to a settlement, you proceed to a common issues trial. A common issues trial takes issues that are common to all class members or to a subset of class members. These issues are defined, by the way, on the motion for certification when certification is granted. And it tries those common issues, often with the evidence of only the representative plaintiff. One plaintiff stands in the position of all of the people in the defined class. Practically speaking, there are usually some subclasses, different representatives of different groups within the class, but we're talking about a trial with a relatively small number of plaintiffs giving evidence on behalf of a large group. That common issues trial may resolve the action in its entirety. If it does, then you go to the process of having fees approved and ultimately money distributed to class members through administration. There's a whole professional world of administrators who specialize in distributing money from a class action, just as you would with a settlement, from a successful decision on the merits. You would get money to class members. But it may be that after that class action trial, you've resolved some important issues, but as we were discussing with Professor Verbeek earlier, there remain individual issues to be determined. Individual issues trials are a possibility, but courts can be creative in assessing how to resolve individual issues, and we have seen a wide range of processes available to resolve individual issues that do not necessarily require a judge, do not necessarily require a court. They can require an administrator who has been appointed to adjudicate on a specific question. If it's a simple question, a referee. We have had arbitral panels. We've really had an opportunity to build creative solutions to reduce the burden of resolving these individual issues, because if you go from a large common issues trial with millions of plaintiffs, individual issue trials that require those plaintiffs to come before a court and demonstrate some aspect of their claim, the practical result is that the class action fails insofar as it never gets to the stage of administering the fund, administering damages, paying money to plaintiffs. So that's the anatomy of a class action. It obviously has more steps that aren't in the diagram, and we could talk about some of these. It is a flexible tool. It is one that is closely managed by judges at all steps, right from the initiation of the claim. It is one that only works with significant cooperation between lawyers and the court, and between lawyers for the plaintiff and lawyers for the defendant. And it is one that over the course of 25 years, I think, has become increasingly sophisticated, but also has become increasingly efficient in Canada as we've resolved some of the initial procedural issues. What I propose to do is take any questions here on this stage of the presentation as to the groundwork for a class action before we launch into the practical training module. And I know from our timing, we were also supposed to have a coffee break. Is that right? Is that at 11 o'clock? So why don't we take some questions, and then what I'll do is I'll set up our first training module.
Gracias. Michael, explicaste que podía haber un acuerdo, en caso de que no hubiera acuerdo se iba al juicio sobre cuestiones comunes. ¿Cuáles suelen ser, en términos generales, las causas por las que no se aprueban esos acuerdos? Y hago la otra pregunta, porque son dos y así puedes responder las dos juntas. ¿Se fijan daños punitivos habitualmente en las condenas? Y en caso de fijarse, ¿los destinatarios de los daños punitivos son los integrantes de la clase o alguna organización fuera de la clase? ¿Alguna organización de beneficencia o vinculada con el tema? Gracias.
Gracias. So 2 questions, settlement and punitive damages. So settlement, and we're going to come to this in our practical exercises because we have a module on settlement. The judge who comes to approve the settlement can do one of 2 things, and only 2 things. Can either approve the settlement or reject the settlement. Cannot renegotiate the terms of the settlement. Practically speaking, the judge will often meet with the lawyers in chambers, not in open court, and say, I would suggest to you that an appropriate settlement would incorporate the following. But formally speaking, it's up or down. The judge either accepts or rejects. If the judge rejects the settlement, there is no settlement. It does not bind anyone other than the plaintiff who agreed to it. It does not bind the class. And the class must either continue to litigate or abandon the proceeding. And practically speaking, what has happened in the very few cases where a settlement has been rejected, because remember, by the time you're proposing that settlement, you have had some dialogue with your judge. You understand roughly where the goalposts sit. In those cases where the settlement has been rejected, continued negotiation occurs, and the plaintiffs come back with another settlement to propose to the class, first the class and then to the court. It's the plaintiff's onus to establish that the settlement is fair, and they often do so. So the example I can give from one of my own cases is a case arising from the distribution of tainted blood tainted with hepatitis C in the Red Cross's blood system through hospitals. The initial settlement created a fund, $1.18 billion. The fund was to revert to the governments, the defendants that were paying money into this fund, and if it wasn't used, it would go back to them. And the judge who was hearing settlement approval, one of our most distinguished class action judges, Warren Winkler, former Chief Justice of Ontario, said, that's not fair, I cannot approve this settlement. It is not acceptable that the money automatically goes back to the defendants. There should at least be the possibility that the money is paid to the benefit of class members. Perhaps class members get it, perhaps defendants get it. I'm going to suggest to you that this would be an appropriate thing to incorporate into the settlement agreement. The parties, of course, went away, further negotiations. They ultimately adopted that change to their settlement agreement. They came back for approval, and at that point, approval was granted. But there's a dynamic there, a dance between the court exercising its supervisory jurisdiction and the bargaining between lawyers. With respect to punitive damages, so punitive damages are available in class actions. Class actions do not change the substantive law. They're merely a procedural device. So the underlying substantive law remains the same. If punitive damages would have been appropriate in an individual case, they may be appropriate in a class action. And just as they would flow to the individual who has suffered harm in an individual case, they flow to the individual members of the class in a class action. And they are distributed through the ordinary administration of the settlement amount if it's a settlement, although you would rarely settle with an express recognition of punitive damages. More commonly, it would be from a judgment at trial that awarded punitive damages, and ultimately those would be distributed to the members of the class. Yes?
Hola, Michael. Sí. La pregunta que tengo es con respecto a los elementos que toma el tribunal para certificar a una clase como tal. Entiendo que este proceso de la certificación que tienen ustedes tiene que ver con evitar demandas temerarias, digo, no sé si tiene traducción, pero demandas porque sí, ¿no? Y que pueden afectar mucho a los demandados. Entonces, supongo que también hay algunos casos en los cuales el tribunal está en el proceso de certificar a una clase, pero sin querer tal vez evalúa cuestiones de mérito, de fondo de la demanda. Entonces, en estos casos difíciles, ¿cuáles son estos elementos que utiliza el tribunal en general?
Sure. So our first exercise is going to be a certification exercise, and we'll look at the criteria that the court uses. It comes right out of the statute, and we'll go through each of these. There are 5 criteria that are applied, and we'll look at a case that illustrates each one of them. But as you say, these are merits blind. These are really about the structure of the case in a formal sense. That said, the feeling amongst many class action practitioners in Canada has been that a class action is subject to what we would call a smell test. If it looks like a good class action, courts will, it is suggested, bend these objective criteria, these procedural criteria, to ensure that it's certified and to ensure that plaintiffs get redress. On the other hand, if it looks like a bad class action, if it looks like something where there aren't real plaintiffs who have suffered real injuries and who want redress, the court may bend these criteria to deny access to the class action procedure. This is all informal. It never appears in the reasons of the court. The court will follow these objective criteria and will justify its decision on the basis of the statute. But there is, at this contextual level, I would say, an assessment of the claim. And it's in part because of that subjective aspect of it that on a motion for certification, the amount of evidence is extraordinary. It is binders and binders and binders of evidence about the merits of the claim, despite the fact that the merits don't matter and are not to be considered at the certification stage. It's really trying to explain to the judge, I think at a subtle level, this is a good case. People have been hurt. You need to let this proceed as a class action. And that's part of the dynamic of litigating these kinds of cases. It's recognizing, as much as it's an objective series of questions to be asked, there is subtext. Yes. Sí, por favor.
Yo voy a pedir. No hay problema. Yo quería hacer una consulta puntual, porque al respecto, cuando arrancaste a hablar sobre el procedimiento, dijiste que solamente se beneficiaba a aquellos sujetos que estuvieran inscriptos en la demanda, o sea, que estuviera el nombre de ese afectado. Entonces, mi duda es puntualmente cómo es el sistema de conformación del grupo en el modelo canadiense, si es por opción de ingreso o por opción de salida.
Es una pregunta excelente, and it highlights, as I said, it's a more complicated diagram than what I've put up here, but a very important part of our class action system is certification is granted, and it is mandatory that you give notice in a manner that is intended to reach class members. Intended to reach class members does not necessarily reach class members, but the court will that explains the notice requirements of what the defendant and plaintiff's counsel must do in notice of the class action. Magazine, it can involve a distribution directly to the plaintiffs if their identities are known. Oftentimes, for example, we were talking about banks with Professor Verbeek. The bank knows who its clients are. It can provide a direct mailing advising them that there is a class action. It's being certified. These are their rights. And the point of giving notice at this stage, once a class action has been certified, is it gives plaintiffs who are now presumptively included in the plaintiff class an opportunity to opt out. You have to take an affirmative step to opt out of the class action. And so, if you do not take that affirmative step, you are, so long as you fall within the four corners of that definition of the class, you are a member of the class. If the class succeeds on its claim, you succeed. If the class loses, you lose, and you will be bound by that result, and you'll be bound by that result whether or not you ever knew about the class action. And so this stage after certification and providing notice is important because it is what gives plaintiffs an opportunity to make a meaningful decision about their rights and the exercise of their rights. If you do not get notice right, if you do not make it reasonable, if you do not ensure that it has a good prospect of reaching class members, then that choice to continue with the class action is illusory. But the default remains promoting access to justice by automatically including those who fall within the class definition. You do not have to take an affirmative step to be a member of the class if you come within the class definition. As between the choices of having to take a step to be part of the class or having to take a step to be excluded from the class, we've decided you have to take a step to be excluded from the class in order to promote access to justice, in order to promote class actions, and ensure that they get the economies of scale that Professor Verbeek was talking about. So that's the dynamic of opting in to the class. I should say one complicating factor, in some provinces, not my province, but in some provinces, where class members who come within the four corners of that definition do not reside in the province, for example, reside in other countries. International classes are possible under our legislation. They may have to take the affirmative step of opting into the class action, of saying, I, resident of Chile, would actually like to be part of your Canadian class action. In my province, however, it is possible to include an international class, and we'll see an example of this in the cases we look at, an international class on an opt-out basis. In other words, the court certifies that action, and it defines a class that automatically includes me, the Chilean resident, in a Canadian class action. So it's an extraordinarily powerful tool in terms of aggregating causes of action, claims that go beyond provincial borders, go beyond national borders, and are intended to ensure that all those who are similarly situated see their case resolved in a single forum.
Hi, Professor. I will try to speak in English.
Gracias.
So, we've been considering all morning long disputes between private parties, okay? So, I'd like to know if there is much significant public law litigation carried out through the class action mechanism in Canada, and if there is judicial fees for the lawyers which carry out these actions.
Sure. So the causes of action that can be advanced in class actions are unlimited, and any case can be advanced in a class action if it satisfies the form of a class action, the criteria we're going to be looking at. against any defendant, including government defendants. It's an incredibly flexible procedure, at least as conceived in Canada. And it is advanced by private attorneys who require no further qualification than that they are hired by the original plaintiff who commences the action, and ultimately on certification that their litigation plan, and really the attorneys themselves, again that subtext, are approved by the court to represent the class. In terms of the fees that they will obtain, as I said, those fees are really a private agreement initially with the representative plaintiff that is ultimately blessed by the court or adjusted by the court as need be. And it is intended, as Professor Verbig says, to incentivize those private attorneys to undertake, at least in terms of behavior modification, what are public goals, regulatory goals for the benefit of all in society. In my province, there is no public authority that prosecutes class actions. There is only a private bar of attorneys. And the alternative to this private prosecution is simply the regulatory state. You can either go to a regulator who is charged with supervising this particular area of the economy, or you can have a class action. And really the value of class actions from a social perspective is where they step in a case of regulatory failure. In other words, the regulator has not acted, it appears that there's a wrong, a private litigator is able to step in. In other provinces, and particularly Quebec, there is standing for consumer organizations to commence a class action on behalf of a group of affected plaintiffs, even though the consumer organization is not itself a plaintiff. It hasn't actually itself suffered a loss. But we do not have a central government figure like an ombudsman who is charged with prosecuting a class action in the public interest. The way we get to public interest is by incentivizing private actors to act in their own self-interest with the added benefit that it advances the public interest. I have certainly studied systems, in particular European systems, that depend on a public actor, an ombudsman. I understand the rationale for that innovation. I understand the distrust of private attorneys general who are self-motivated. The difficulty is I have yet to see a system in which that public actor produces the same volume of actions, the same robust class action jurisprudence as does this system. Now again, it's a normative judgment as to whether that's good or bad. This may create over-litigation. This may represent self-interested attorneys using the leverage of that certification to extract from a defendant unjust amounts by way of settlement on claims that actually, if they went to trial, have no merit, but because the stakes are so high, they force settlement. It's not to say this is the right way to do it, it's just that it's the only way that I've seen that actually develops hundreds of class actions and the kind of robust jurisprudence that makes this procedure efficient, the kind of experienced practitioners that are able to specialize in class actions and really develops a system in which a defendant understands that if it is accused of engaging in a mass wrong, it will, with a fairly high degree of certainty, face a class action. Por favor, señor.
Gracias. Tengo una pregunta. Me parece interesante plantear la posibilidad que ocurre si una persona que no entra legalmente a Canadá o se queda ilegalmente después que expiran los documentos de visado, puede ser certificado como integrante de la clase para efecto de presentar este proceso.
Absolutely. The test is whether a Canadian court can properly assume jurisdiction over the matter. And so if, for example, injury was suffered while a person was in Canada, whether legally or illegally, the Canadian court, would have very good reason to assume jurisdiction over the matter, even if that person had subsequently left Canada or had been in Canada illegally. And in the second module we look at today, the common issues trial, it is precisely that case where the injury is suffered in Canada by people who have, for the most part, left Canada, but are seeking redress in a Canadian class action because they prefer that vehicle to the remedies that are available in their home countries, in this case, India and China. And I can think of a contemplated class action for migrant farm workers who had come to work in Canada, been injured, their visas had expired, they had left, and they were seeking redress for injuries suffered within Canada. The vehicle of a class action extends justice to those individuals insofar as the Canadian court can assume jurisdiction over the claim. And it will assume jurisdiction over the claim, as we'll see when we come to our second module, even if the defendant is able to make a case that the judgment of a Canadian court will not be recognized in the home country of the plaintiff. The example being China. There was expert evidence led, as we'll see, that in fact a Chinese court would not recognize a decision on the merits in a Canadian class action and might well let the Chinese plaintiff continue to pursue the defendant in a Chinese court. That was not a bar to certifying a Canadian class action. So again, a hugely flexible tool that is really aimed at trying all of the common claims together. Otras preguntas? ¿Todo? Okay.